morning. I'm Jerry Sagona, Vice President of Business Development with the Rockford Area Economic Development Council. Today we present a webinar on navigating COVID-19 legislation and the impact on employers presented by the law firm Hinshaw Culbertson. The Rockford Area Economic Development Council is hosting these webinars as a service to our community to provide meaningful information to help businesses reopen during this pandemic. Please visit our website for other COVID-19 resources. In addition, there are two other webinars scheduled this month. On May 21st, the topic is Crisis Leadership with Dr. Mandolin Mull with Rockford University. And then we have Hinshaw Culbertson coming back on May 27th, and the topic is How Small Businesses Can Navigate the Pandemic with Jim Keeling, Leek, and Matthew Hevron from Hinshaw Culbertson. Check RAEDC's website for additional details on the webinars and to sign up. So let's get things started. Today's webinar is scheduled for 1 hour, with the last 15 to 20 minutes reserved for questions and answers. Please submit questions throughout the presentation through the question chat function feature on your screen. This morning, I'd like to welcome Jim Paragus, Mary Jo Paragus Reynolds, and Evan Bonnet. James, who will be our first speaker, has more than 30 years of experience representing employers in labor and employment matters. James regularly counsels employers with regard to investigations of unfair labor practice charges and discrimination charges, and in proceedings before the National Labor Relations, Illinois Labor Relations Board, the Illinois Educational Labor Relations Board, the Illinois Department of Human Rights, and the Equal Employment Opportunity Commission. Mary Jo defends the interests of employers in a range of labor and employment matters. She helps businesses navigate the ever-changing legal landscape in order to limit their liability and exposure, and advises them on their contracts, policies, and handbooks. Finally, Evan's focus in the firm is in representing employers in labor and employment matters. His practice includes advising on compliance with state and federal regulations, labor relations, workplace standards, and medical leave requirements. With that, I'll turn over the microphone to James Paragus.
Thank you, Jerry. Good morning, everyone, and welcome to our webinar on COVID-19 legislation and the impact on employers. On behalf of RAEDC and on behalf of Hinshaw and Culbertson, we welcome all of you to this and hope that we'll find this to be useful. I'm going to present it first and give you an overview of the Family First Coronavirus Response Act. There's lots of materials there that we'll be dealing with over a fairly short period of time. Mary Jo is then going to address with you the unemployment provisions under the subsequently passed CARES Act. And then Evan will be finishing up with a discussion of return to work considerations in light of COVID-19 and related conditions. So without further ado, let's talk first about what is covered by the Families First Coronavirus Response Act. As this slide notes, and I won't dwell on this for too long, but you'll note the very accelerated time frame that was applicable to the passage of this law. It was just over a month between the time that the president declared national emergency and the enforcement of the FFCRA began with the U.S. Department of Labor. From a lawyer's perspective, we had a very interesting time with I'm sorry. I'm having some technical difficulties here. Sorry. Okay. Thank you to Mary Jo for her technical assistance. From a lawyer's perspective, we were seeing, the law came out, the regulations took a while longer to come out. And then once the regulations came out from the Department of Labor, it seemed like we were getting updated, changed Department of Labor guidance and questions and answers on pretty much a daily basis for a few weeks. And then since then, we've also had regulations issued by the EEOC with regard to COVID-19, and those too have been changing as the weeks have gone on. But this slide just merely illustrates the exceedingly fast time frame applicable to the passage of this law and its enforcement. A key thing is it became effective for all employers as of April 1 of 2020. Now it is not allowing me to move forward. Bear with me just a minute. I'm having a hard time getting this to move forward. Okay, so first of all, let's talk about the paid sick leave provisions of the Families First Coronavirus Recovery Act, Response Act. The paid sick leave provisions allow or are applicable to both public and private sector employers with fewer than 500 employees there, then that number is measured at the time the leave is to be taken. And as the slide notes, provides for up to 2 weeks of paid sick leave if the employee is unable to work or to telework because of basically 5 different situations as noted on this slide. First, that the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Secondly, that the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Third, the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. And fourth, the employee is caring for an individual who is subject to such an order, either from a governmental entity on a quarantine order or from a health care provider's self-quarantine recommendation. Or fifthly, the employee is caring for a child if the school or place of care of the child has been closed, or the child care provider or care provider of the child is unavailable due to COVID-19 precautions. So basically, the first 3 deal with the employee's own situation. Either the employee is subject to a order from a governmental entity on quarantining or isolating, or the employee in number 2 has been ordered or recommended by a healthcare provider to self-quarantine, or the employee is experiencing symptoms. And then number 4 and 5 deal with the employee taking care of someone else, taking care of another individual who is subject to one of those quarantine orders, or they're taking care of a child because their school, daycare provider, or place of care is unavailable due to COVID-19 precautions. Now, there is a 6th kind of catch-all that says that the employee is experiencing any other similarly or substantially similar conditions specified by the Secretary of Health in consultation with the Secretary of Treasury and the Secretary of Labor. As of this point, there have been no other substantially similar conditions that have been identified under number 6. So for purposes of our time together this morning, we'll be talking primarily about the first 5. Also note with regard to item number 1 on this slide, and as the note points out, there is some uncertainty as to whether a federal, state, or local quarantine or isolation order related to COVID-19 applies to a stay-at-home order such as that which has been issued by Governor Pritzker here in Illinois as of March 20th. A footnote in some of the Department of Labor regulations would indicate that that may not be applicable to such an order by Governor Pritzker or any other governor or state agency. But for purposes of our advice to you on this, we would say that the spirit and intent of the Employee Paid Sick Leave Act would have applicability of such a stay-at-home order from the governor would be included under the type of leave covered under item number 1. So who is entitled to paid sick leave under this law? First of all, it applies to all employees who, regardless of their length of service. So there is no, from day 1 of employment, the employee who is otherwise eligible for paid sick leave is eligible for that benefit. Now, there are exceptions for healthcare providers who may be excluded, as may emergency responders. So healthcare providers may not be entitled to paid sick leave, as well as emergency responders would be may be carved out from coverage under paid sick leave. And there's also a provision which allows an employer who's a small employer, one with less than 50 employees, if they can certify that providing childcare related paid sick leave would jeopardize the viability of the business. So keep in mind that with regard to this exception applicable to small employers, it is only with regard to childcare related paid sick leave, not the paid sick leave applicable to the employee itself. And then with regard to child care related paid sick leave, they may be exempted from coverage under paid sick leave if they can show that it would jeopardize the viability of the business. The next slide talks a little bit more about this small employer exception. It said that they would qualify here under any one of these three exceptions. And I'm not going to read them all to you, but it would basically they're connected either with the expenses connected with employee paid sick leave exceed the available business revenue, or under numbers 2 or number 3, that allowing the employee to take the time off, or the availability of other workers if the employee takes the time off, would jeopardize the financial health and operational capabilities of the small business. But again, this applies only as an exception to child care related paid sick leave for this small employer exception. How much employee paid sick leave does an employee who's eligible receive? Well, for full-time employees, it's up to 80 hours. For part-time employees, it's the number of hours that the employee works on average over 2 weeks. There are also regulations and guidance provided for part-time employees who work irregular number of hours, and some different options that you have in calculating the number of hours that that individual receives. But generally speaking, it's 80 hours for a full-time employee, and for part-time employees who have regularly scheduled hours of work, it's the number of hours that they work over a 2-week period. If an employee is taking paid sick leave for reasons number 1, 2, or 3 that were shown on slide 7, that's the leave due to a quarantine order by the government, or a quarantine recommendation by a healthcare provider, or because the employee, him or herself, is seeking treatment for COVID-19 symptoms, then the sick leave is paid at the employee's regular rate of pay and is capped at $511 per day, or a total of $5,110 during the entire 2-week period. Now, regular rate of pay is a whole nother discussion that we don't have the time to go into, but there are varying regulations that have been issued regarding how you compute the regular rate of pay that you should take note of. The regulations are available on the Department of Labor's website. Now, when the individual is taking paid sick leave due to caring for another person other than the employee, him or herself, or because they have a child that they're caring for who is needing their care because of the unavailability of school or daycare, then it is 2/3 of the employee's regular rate. So it's their regular rate if they're taking care of themselves, but it's 2/3 of their regular rate if they're taking care of someone else or they're taking care of a child. And in that event, the pay for employee paid sick leave is $200 per day, or a total of $2,000 in aggregate over that 80-hour or 2-week period. Documentation: what kind of documentation may an employer require in order to be obligated to provide this kind of leave? Well, the employee has to provide documentation, which is noted under the first bullet here, stating the qualifying reason for the leave, and that the employee is why the employee is unable to work for that qualifying reason, and the dates involved. As noted in the second bullet, if the employee is needing to be absent due to a healthcare provider's recommendation, they can require information be provided from the healthcare provider. An important note is in bullet number 3, with respect to tax credits, and getting a little bit ahead of myself, but all this money that you pay out under employee paid sick leave, and as we'll talk in a few minutes, under expanded FMLA, is eligible for tax credits. And so it's of the utmost importance, if you're going to take those tax credits as an employer, for you to maintain this documentation, because the IRS will may require that kind of documentation in order to allow you to take tax credits. So as a takeaway, it's important for you to require and maintain the documentation that the law describes to better position yourself to take the tax credits when the time comes. And as is noted at the end of this slide, the IRS may issue forms and further instructions on what is needed to support a tax credit claim for paid sick leave. So that's a quick overview of the employee paid sick leave. Now moving on to A second part of the Families First Coronavirus Response Act is emergency FMLA leave. The expanded emergency family medical leave expands the reasons for which FMLA leave may be taken that are provided in the established FMLA, which has been on the books since 1993. So basically, it's not a new type of leave, it's just giving an expanded reason for someone to qualify for FMLA leave during the period that this law is in effect, which goes into effect from April 1 of 2020 through December 31 of 2020. And it applies, this type of leave applies to all public employers with fewer than employees, and requires them to provide 12 weeks if an eligible employee is unable to work or to telework because they are needed to care for a child under 18 years of age, if the school, daycare, place of care has been closed, or the child care provider is unavailable due to a public health emergency such as COVID-19. So expanded FMLA applies only to leave taken to care for a child under the age of 18. And there are exceptions to that for children over the age of 18 who have a disability. But generally speaking, it's for a child under the age of 18 who needs the employee to be in place to provide care as a result of the school, daycare, or place of care being otherwise unavailable due to COVID-19. Now, it's important to note that this is not an additional entitlement to another 12 weeks. It is just another reason for an employee to use the 12 weeks of FMLA that are already provided by that statute. So, for example, if an employee needs to take leave off to take care of a child due to COVID-19 and they've used no FMLA time under your FMLA policy during the past 12 months, then they have the full 12 weeks of time available for taking care of that child due to COVID-19. If, however, the employee comes into the use of FMLA for childcare purposes and they've used already for other reasons, let's say 10 weeks of their 12 weeks of FMLA during that 12-month period, then they only have 2 weeks of FMLA time remaining that they can use under this expanded emergency leave due to COVID-19. Who is entitled to EFMLA? Well, you know, under regular FMLA, the requirements are that the employee had to have worked for you for 12 months and have worked 1,250 hours in the 12-month period prior to the leave. This kind of leave, the expanded FMLA for COVID-19, applies to an employee who has been employed for at least 30 calendar days. So they've reduced the eligibility requirement for EFMLA to 30 days as opposed to standard FMLA, which has a 12-month period requirement. Here it's only 30 calendar days. Again, an employer with fewer than 50 employees may be exempt from this expanded FMLA if they can show that it would jeopardize the viability of the business, as was noted with regard to employee paid sick leave. And the Act also exempts employers with fewer than 50 employees in a 75-mile radius from damages in a civil lawsuit, but does not exempt such an employee from enforcement actions by the U.S. Department of Labor. What is required to be paid during an expanded FMLA? Well, it's noted on this slide, the first 10 days may be unpaid. So the first 10 days of the expanded FMLA can be unpaid, but the employee may choose to substitute accrued time under an existing employer policy, or the employer who's eligible for paid sick leave may use that to cover that time of the first 2 weeks in lieu of going unpaid. Now, mind you, though, that if the employee uses the paid sick leave for the first 2 weeks of expanded FMLA, it's paid at only 2/3 of the employee's regular rate because they're taking it to care for someone else other than themselves. And in all those circumstances where either expanded family and medical leave or emergency paid sick leave are paid for taking care of a child or someone else other than the employee, that's paid at 2/3 of the employee's regular rate as opposed to the employee's full regular rate. after the 10 days of unpaid leave are taken, or if the employee has substituted some other form of paid leave in lieu of unpaid time, then the employer has to pay the employee during the balance of the expanded FMLA time at 2/3 of the employee's regular rate of pay. But as is noted here, the paid leave is capped at $200 per day and at $10,000 total during the additional time allowed by the expanded FMLA time. Again, with documentation, the employer may require that the employee provide documentation similar to that noted with regard to paid sick leave. For example, if they're using this time because a school or daycare center is closed, the employee may have to provide information from the school or daycare provider's website, or an email from the employer or the daycare provider or school that the place of care is no longer available, would suffice as well for proving documentation to take this expanded FMLA time. And again, the importance of maintaining that documentation, obtaining and maintaining the documentation can't be overstated if the employee wants to take a tax credit for allowing the employee to take that time and to recoup the money as a tax credit at the end of that time period. Again, the IRS may issue forms and further instructions on what is needed to take a EFMLA tax credit. As is noted here on my last slide of my presentation, employers may begin to take advantage of new refundable payroll tax credits applicable either to the payment of the emergency paid sick leave or the expanded FMLA for COVID-19 related reasons. The IRS is to allow employers to offset their federal income and payroll withholdings by the amount of paid sick leave paid for either of these two benefits under either of these two new laws. And then if there are not sufficient payroll taxes to cover the cost of the monies that have been paid for this purpose, then the employee can file a request for an accelerated payment from the IRS. And the IRS is expected to process those requests in 2 weeks or less. So in essence, employers are paying employees for the amounts paid under these two new laws, the paid sick leave and the expanded FMLA for COVID-19, by using trust fund taxes that were previously going to be withheld from an employee's paid and paid over to the government. So that ends my presentation. I'm going to pass this on to Mary Jo, who will be talking about unemployment under the CARES Act.
There we go, I was muted. Good morning, everyone. Thank you so much for having us. A big thanks to the EDC for all you're doing to help our community during this challenging time. As Jim mentioned, I'm going to address unemployment under another new statute called the CARES Act. CARES stands for Coronavirus Aid, Relief, and Economic Security Act, and this was enacted after the Families First Coronavirus Response Act. Title II, Section A of the CARES Act deals with relief for workers affected by coronavirus, and it enhances eligibility for unemployment benefits. And I think it's important for all of us to have a general understanding of the broadened access to benefits, not only to help our employees, but also to help our friends and families know what they might be eligible for and to get access to much needed benefits. I read recently, I think unemployment claims are up to 36.5 million, which is obviously a very staggering number, and people need help right now, and so that's the point of this statute, and we're going to dive into some of the expansion. Several pieces to that. There's expanded eligibility, there's an increase in terms of duration, there's an increase in terms of benefits available, and it's important to note that previously unemployment benefits were exclusively administered by the states. And while the states still get to establish certain thresholds for eligibility, under the CARES Act, unemployment is now going to be temporarily a joint federal and state program. And so the federal government is going to work with the state government and in some cases reimburse for various benefits. To begin, when we're thinking about what's changed with unemployment, one of the things that likely you're aware of, because it's gotten a lot of publicity, is the fact that anyone who qualifies for unemployment is going to receive an additional $600 a week. And in Illinois, that money became available beginning March 29th, and it will be available pursuant to the CARES Act until July 31st of this year. So its availability is a little more limited in duration, but that additional $600 is quite significant. That money will be reimbursed by the federal government. And it's very important to note that if you qualify for even a pretty minimal amount, such as, a couple $100, even just $1 of unemployment under state law, you're automatically eligible to receive that $600 a week. So that's, really impacting people's pocketbooks right now. Another change, in addition to the increase in amount, is an extension of the duration for unemployment. And previously, an individual could get a maximum of 26 weeks, but the CARES Act provides for another 13 weeks, making the maximum length 39 weeks. And again, this additional 13 weeks will be reimbursed to the state by the federal government. Not only is the duration extended and the amount enhanced, but there's also an expansion in terms of who can even qualify for unemployment benefits. And people who were previously ineligible, such as independent contractors, gig economy workers, those who were self-employed, previously would not have qualified for unemployment benefits under state law, but now these individuals do qualify because of the CARES Act. And so pretty much high level, if your employment status has been negatively impacted because of COVID, you likely qualify for unemployment benefits, including that additional $600. This would include people who are laid off temporarily or otherwise, and people who are furloughed. This slide summarizes some of the categories of eligibility under the CARES Act. In the interest of time, I won't run through those, but you can see it's a rather extensive list. And again, high level, if your employment status has been negatively impacted as a result of COVID, most likely you qualify for unemployment benefits under the CARES Act. The state of Illinois had kind of put a pause on the receipt of unemployment benefits for people who previously would not have otherwise qualified. And more recently, they gave guidance regarding the application process for those who are self-employed, those who are independent contractors, those who are gig economy workers. And it's a little wonky, but essentially those individuals do qualify because of the CARES Act, but they have to apply, they have to be denied, and then they have to appeal their denial, and then they can claim the federal benefits. So not the system I think many of us would have created, but the state is trying to act quickly and try and get those people these much needed benefits. And so that's the process they settled on. And if you are a worker eligible, you need to be aware of that process, frustrating as it may be, and make sure you're pursuing your appeal. There's been some changes made in terms of the standard 1-week waiting period. The CARES Act did not eliminate waiting periods, but it incentivized individual states to do so. And Illinois is a state that previously had a 1-week waiting period, and because of the incentive of the CARES Act, temporarily is suspending that 1-week period, and that 1 week of unemployment will again be reimbursed by the federal government. So be aware that there is currently no waiting period, and that will continue during the duration of the governor's disaster proclamation. So we've talked about how the eligibility for unemployment benefits has dramatically increased and who is eligible. Let's talk about who wouldn't be eligible. Anyone who's receiving the benefits that Jim described under the Families First Coronavirus Response Act would be ineligible for unemployment because they're receiving other benefits. They're still receiving pay. Anyone who's working from home without a reduction in hours is ineligible for unemployment because they're receiving their standard wages. They're still working. In most instances, individuals who have received a salary reduction are still ineligible for unemployment because they're still working, they're still receiving wages. Essentially, anyone who receives $484 or more a week is ineligible for unemployment. So there can be some exceptions, but normally people receiving, full wages, even if they're reduced, would not qualify for unemployment benefits. Briefly, we'll discuss chargeability. We've gotten a lot of employer questions about this because some states are enacting legislation that reduces employer chargeability, but we don't expect that Illinois will do so. And IDES actually addressed this in an FAQ and said the contribution rate of an experience-rated employer is based on, in part, the amount of unemployment benefits paid to the employer's former employees. So this rate may in fact rise when an employer furloughs or lays off employees because of COVID-19. So in terms of planning, if you're an employer, be aware that the increase in claims for unemployment may have a negative financial impact in connection with chargeability. Another thing that's been getting a little bit of buzz is the concept of a work share program. Illinois has a statute that allows for this type of program, but they've never actually enacted the program itself. So presently, while this has been contemplated by the legislature and approved, it's never been rolled out, and so therefore it's not currently in effect. But the CARES Act incentivizes states to enact work share programs, and this would be an alternative to a traditional layoff and furlough. And a work share program would have an employer simply reduce the number of hours employees are working and then use partial unemployment compensation to make up the difference. So, plug this away in the back of your mind as something we anticipate and frankly hope that Illinois may roll out that may give you as an employer another tool in your toolbox, but presently it's not in effect in Illinois. And my last slide provides links to various resources. IDES has created several helpful FAQs, both for claimants and employers. And so I highly encourage you to consult that when, grappling with these very difficult employment decisions. I also suggest, that if you have a friend or a family member in need, refer them to these websites and, try and encourage them, not to give up. They may have to appeal, but likely if their employment status has been negatively impacted, they probably qualify for some of these benefits, which could, be significant for them. So thank you for having me today. With that, I'll turn it over to my colleague, Evan Bonnet, who will discuss some practical considerations in terms of return to work.
All right, good morning, everybody. Thank you for joining us and for RAEDC for having us here. Looks like I'm properly sharing my screen, so that's always good news. Make sure I can advance it. Okay, again, I'm Evan Bonnet, work at Hinshaw with Jim and Mary Jo. I'm glad to be here this morning to be able to talk to you about some of these issues. As employed to work from working from home, being furloughed, laid off, employers are going to see several new issues and quite a few kind of new twists on existing issues that have been around for quite some time. As a general scope of what I'll be talking about, I'm going to talk about actions to limit the spread of coronavirus, managing reasonable accommodation requests, requests from employees wanting to continue to work from home, as well as some safety compliance issues and discrimination risks. The EEOC, kind of similar to how we've watched the other statutes and regulations underneath them evolve over the last 2 months. The EEOC has issued several iterations, I think we're up to 7 or so, of ongoing and ever-changing guidance since mid-March about how they recommend handling things like testing and screening. Primarily, these ADA, the Americans with Disabilities Act. To be clear, COVID-19, the disease caused by the coronavirus, is not likely to be a disability, at least not yet. There hasn't been a definitive ruling in the regulations about that, but I wouldn't anticipate. Some of the things that could potentially cause in people, some of the ongoing damage that we're starting to see, maybe potentially could be a disability. But at this point, we're more concerned about what kind of screening and testing can we do with employees under the ADA. Measuring an employee's body temperature or something like that is ordinarily not permitted because it's viewed as a medical examination, and those are ordinarily, along with other disability-related inquiries, prohibited unless they are job-related and consistent with business necessity. So a fitness for duty exam, something like that, is often what we're thinking of. There's another thing, though, however, called the direct threat standard, and that allows testing or other examinations if there's going to be a significant risk of harm to the health or safety of the individuals or others that cannot be eliminated by a reasonable accommodation. So based on that standard, the EEOC has essentially stated that we now have an exception, and based on CDC guidance, the EEOC determined that COVID-19 does present that sort of a direct threat. An employer may bar an employee from the disease from entering the workplace. Employers therefore have some leeway with developing infection control strategies without violating the ADA. Again, things that otherwise wouldn't be allowed. Again, these discussions from the EEOC about allowing testing under the ADA have been expanding and using the existing framework, but expanding some of the ways the ADA is being interpreted with regard to this disease. But they have not changed any guidance with respect to other discrimination pieces. So you've got age, pregnancy, racial discrimination, those sorts of things. There's no exception to that. The EEOC does not have guidance or protocols for how to administer the tests. For that, we recommend looking at FDA and CDC guidelines online. Generally, though, employers may ask their employees if they feel ill, if they've had any symptoms, bar them if they report a yes answer to those things, or if they refuse to answer, and bar them from the workplace, that is. Measure temperatures and administer an actual test, provided that one becomes available that's usable by an employer on a basis, as long as that test is accurate and reliable. So there are some more examples, particularly I think to the FDA, with some providing the tests, kind of outside of the scope of talking about it here, but just wanted to raise that as possible concerns. The key point is the EEOC has made very clear that employers continue to have an obligation to maintain confidentiality of employee medical information. The same. So those records need to be segregated and kept apart from other employment records like a personnel file. And they need to be available only to those individuals of the employer that have a need to know that particular information. Logs of temperatures are okay, so you could have a daily log of all the employees' temperatures. That information, however, continues to need to be confidential in the same way as other medical information. Same thing with follow-on testing. Some employers have discussed having a kind of an initial screening and the questions that I mentioned, and then following that with an actual test or temperature taking, or first and a second stage. If employees are being pulled to go conduct additional testing or additional questions or whatever that may be, we just recommend that information, as well as the additional kind of secondary testing site, also be confidential, just to avoid any problems from there. Employers may, some exceptions to confidentiality do allow the employer to disclose the employee's name to the public health officials. So the health department, for instance, if that were to come up, there probably will be some reporting obligations with that, as well as a staffing agency. So if you have some temporary employees and one of them becomes, through your screening process, you notice that they are positive and you're excluding them from the workplace, you can let their staffing company know that as well. Some states have required testing before you can open up. Illinois is not one of them, but it does recommend the type of screening that we've talked about. Okay. All right, on safety policies, back to what Illinois is requiring. Starting on May 1st, 2020, with the new measures of starting to open up the state and have some new policies in place. Essential businesses and manufacturers that are allowed to open are required to provide face coverings to all employees who are not able to maintain 6 feet of social distancing. So whereas the testing is a kind of recommendation, the masks are going to be a requirement, or rather are a requirement. One of the key things here as far as enforcing that, enforcing social distancing, enforcing hand sanitizing, those sorts of things, is just effectively communicating those policies and expectations to employees, ensuring that, and that's really kind of a double advantage. One, it's ensuring that individuals are actually keeping their masks on, for instance, and maintaining the spacing and meeting minimization requirements, those sorts of things, but also letting employees know that you are, in fact, handling this, taking it seriously with regard to their safety. Some of the other issues that routine cleaning, the CDC has guidance, and I've linked that here regarding cleaning and disinfecting. Again, it's one of those that kind of gets into the weeds, but if you've got a cleaning contractor or you handle that yourself, it's worth looking at that and seeing what kind of recommendations the CDC makes with regard to cleaning workplaces, essentially more often, and some deep cleaning things. Also important to review any, especially local requirements. There may be some additional local, county requirements, for instance, depending on where you are, that may obligate that. Additional cleaning or other PPE. Again, with Illinois masks, I think that takes care of that. Again, we do recommend to supply masks. Hand sanitizer should be made available along with other hand cleaning stations. And for anybody who is interacting with the public, we would consider gloves and barriers, for instance, like you'll see at the store right now. There have been some OSHA and CDC joint recommendations that have come out highlighting the PPE issues. I'll note that in a little bit as well, but we would note those are not the OSHA regulations the same way you would see on a respirator in a closed environment, those sorts of things. Existing OSHA regulations and rules still apply if you already have OSHA specific industry standards. Your industry continue. These are recommendations, and the recommendations are all kind of comporting, whether we're talking about CDC or state or OSHA. Finally, make sure you document any training on distancing and hand washing just for your records in regard to OSHA as well. Okay, I won't read through these, but this is some design considerations that are worth considering, and some other administrative things, all of which together can join forces, if you will, to help minimize impact at the workplace. We've touched on it a little bit with some of the other issues, but not only with communicating policies and practices, but also some flexibility with documentation that you may otherwise be requiring just because of the some of the limitations of getting to the doctor, for instance, and those sorts of a thing. But there are other options that include shifting, splitting shifts, having people come at a different time, staggering when they come in, maybe expanding work from home opportunities for individuals that otherwise may not have it. One caveat with expanding working from home possibilities for individuals, if it's an employee that you, absent this coronavirus situation, would not really, they can't accomplish all their essential functions from home, or you're concerned about that, we do recommend clarifying in any grant to the employee that they may work from home, that it's the extenuating circumstances of this particular situation that's allowing them to work from home, and just to avoid them being able to come back, a year from now and saying, well, I can work from home. You let me a year ago, so you should let me now. All right. The employer's obligation to make reasonable accommodations and engage in the interactive process remain in place based on EEOC guidance. So an employee requests an accommodation, you need to continue to engage in the interactive process to come up with what accommodation may help them accomplish their essential functions. If there's something that you're willing to, that's an essential function, like I mentioned, that working from home may not work, but in this particular instance you're willing to allow it, we would just say to make sure that that's clear that it's only because of now. Big caveat here is do not assume that employee is in a high-risk group. Again, I mentioned earlier that things like age and pregnancy discrimination concerns haven't been mitigated by the EEOC. So don't assume that because this employee is pregnant that that you should exclude her from the workplace. Okay. The EEOC recommends that employers should continue to explore potential reasonable accommodation requests with employees in the same way. And the EEOC provides the same sorts of examples that I had there earlier. It was about protective gear. The EEOC calls it protective gear, erecting barriers that provide separation, elimination of particular individuals, modification of work schedules, and moving locations for individuals. The EEOC has made clear that employers do not need to delay any discussions until the employee is required to work. So for instance, if you have an employee who's teleworking, but they're coming back to work is what's raising some concerns with them. The EEOC expects the employer should be able to acquire all the information it needs from that employee and the interactive process and discussion it needs to engage in with the employee before they come back and make those arrangements for accommodation in advance. Okay. One issue that comes up in a lot of hypotheticals, if you will, and some increasingly real as we move forward is what if an employee expresses fear about coming back because he or she has an underlying condition. So again, don't assume it of the employee may bring it up themselves. And if that employee makes an accommodation request, the employer should follow its same interactive process that you've always done. Again, we listed some of the potential accommodations that can arise there. With no underlying medical condition that may constitute a disability, so let's say the employee is just worried about coming back, there's no requirement under the ADA to actually accommodate that employee, teleworking, for instance. But if teleworking is feasible and it's working, again, with the same kind of warnings that we provided earlier about teleworking in this particular environment being an exception, those sorts of things, we'll continue to do that until the pandemic subsides. Other options also become available with paid leave, as we talked about with the FFCRA and other paid sick leave that may or may not arise depending on the particular situations of that employee. One concern, I'll skip over this one just for the interest of time. There's extended leave that's available that we discussed when it comes to an individual who may or may not be able to return to work because of other limitations as well. Okay. One concern with an employee raising a concern about returning to the workplace is retaliation provisions under OSHA, under the National Labor Relations Act, which applies even if you are union employees when it comes to concerted protected activity of complaining about the workplace not being safe, for instance. So in addition to engaging in that interactive process, ensure that employees don't suffer any retaliation for raising those types of concerns. OSHA has not only reporting protocols for workplace injuries that apply to illnesses from the workplace as well, so continue to follow OSHA reporting obligations, but keep in mind that in addition to OSHA's recommendations about safety in the workplace when it comes to coronavirus, there is and still remains the OSHA general duty clause that requires employers to provide employees with a workplace free from recognized hazards likely to cause death or serious bodily harm. So to that extent, we recommend that OSHA guidance and recommendations that have come out, which are not regulations in the same way that they normally are, be viewed as, if you can comply with those, you should be much closer to being able to show that you've satisfied that general duty clause. Again, avoid retaliation against employees who have raised that sort of an issue, both under OSHA and NLRA. As far as quarantine, tracing, and cleaning, we talked about those. One other thing I would raise here is employers should not disclose to coworkers the identity of anybody who's tested positive under the ADA especially, but also potential state laws as well. So we've talked about who you can disclose that to, but make sure if that sort of thing happens, you can do internal tracing and keep that information confidential in the workplace, but don't go around and tell everybody that it was Joe that was sick, and because that would violate the confidentiality concerns. Finally, if you're truly separating employees, so we talked a lot about coming back to work, but we're going to leave on note, and that is if there really are individuals who are being let go, to make sure that things like documenting the skills and performance, et cetera, of the employees that are being chosen or not chosen to be let go is clearly documented so that the business necessity and business decision can be supported by that to help protect you from discrimination claims, that you only picked a certain group of people to be let go and let another certain group come back. And finally, connected to that is if anybody has paid vacation, accrued PTO, bonuses, commissions, that sort of a thing, those need to be paid out as well, even under the kind of economic conditions that we're under now. Those are pay that has to be made at the end there. So just a reminder, if you have any questions, then feel free to submit those to us. And thank you very much for your time, and we appreciate it. And we'll move on to look at some of your questions. Thank you.
Excellent. Thank you so much. We had about 7, 8 questions come in so far. First one, if a company is under 50 employees, can they revoke an employee's use of PSL or EFMLA for child care independent of other employees? Example, that person has a critical position in a manufacturing process.
The question is with regard to a small employer?
Yes, under 50.
I think that the law would allow the employer to certify that the individual was needed for a key personnel, that you could not be sparing that individual for the expanded FMLA, and you could do that for that one individual without necessarily certifying it for other people who may be in a different category. You better be able to demonstrate, though, if you're going to certify the importance of that individual, you better be able to demonstrate that that individual did fit that kind of critical role that would be detrimental to your business if he or she was absent on account of one of either employee paid sick leave or because of EFML.
Another question came in that on an employee self-diagnosis, say they have 2 symptoms such as shortness of breath and a cough. When they go and get tested and the test comes back negative, are they eligible to be paid during the period that they're waiting for the test results to come in?
If the employee was seeking a diagnosis, if they had symptoms and they were seeking a diagnosis from a doctor, that would technically qualify for the employee paid sick leave as well. Well, it wouldn't qualify for FML. It might qualify for FMLA potentially, but not for expanded FML. But once that test result was back, that eligibility would end for the paid sick leave.
Oh, go ahead. I'm sorry.
The eligibility for the paid sick leave would end if they had obtained a negative result as a result of after having sought medical treatment, and if the test result was negative, their eligibility for the paid sick leave would end.
Another question came in about just the general population, the employee count within an organization, that some are uncomfortable coming back to work, that they're concerned about getting the virus. What are the options available for an employer? And the question's also related to is if they feel uncomfortable coming back to work, is the employer still obligated to pay for benefits such as insurance?
Well, we can all chime in a little bit on this one, but I mean, if the employee does not have an underlying condition and the employer has otherwise reasonably provided for a return to work program that should allay any concerns regarding transmission of COVID-19, the employee really doesn't have a justification for not returning. If the employee does not want to return to work, I mean, and the employee has work available, it would seem to me that the employee would either have the option of resigning, the employer could terminate, or the employee or the employer as an in-between option could allow the employee to take some sort of other type of leave if the employer allows a leave, for example, for a personal leave of absence during such an absence. But that individual would not be entitled to any type of benefits under the FFCRA just because, again, if they don't have any underlying condition, it's just a fear of coming back. And the fear is not, let's say, related to a mental health disability, but just say it's just I'm fearful and I don't want to come back. I don't have an underlying condition. And the employer has done everything it can do to allay those concerns, has complied with CDC, has complied with OSHA as far as making the workplace appropriate for their return to work. The employee should not be entitled to any type of paid benefits under these laws, under the Families First Coronavirus Response Act. And either they terminate or resign, or there could be a personal leave that could be considered. Mary Jo and Nate, Mary Jo and Evan, do you have any other guidance on that?
No, one concern I would have is ensuring that if the leave of absence is being offered or used, that it's being done on an equal basis for individuals, and there's not going to be any claim that you let so and so use the leave absence policy and I was excluded from that. There would also be one of the issues related with that was maintaining benefits. Depending on that, the leave of absence could exclude them from eligibility for the health insurance, or that may not, depending on their health insurance policy. But there would also potentially be COBRA as well if a qualifying event occurred with that. So there is the potential for continued health benefits, but just a couple other concerns there.
And I'd echo what Evan said previously and encourage employers to document. Communication right now is pivotal, and employers should be communicating to their employees efforts they're taking to protect employees, availability of personal protective gear, hand sanitizer, social distancing requirements, telework opportunities, and so that should be documented. And if an employee still has a concern, I encourage the employer to listen to them, and if it's reasonable, to try and take action to alleviate that concern, which may not always be possible. But definitely strongly encourage employers to be communicative with their employees.
Another question came in under the category of less than 50 employees. The company did not previously offer FMLA. They were advised that in the current climate, they should not try to claim exemption from the EFMLA. Now that they are complying and offering the EFMLA to staff, after the 12/2020, or after 12/2020, does this set a precedence that would make it difficult to going back to our previous standing of not offering FMLA as long as we're still under the 50 employee limitation?
Well, as long as they we're talking after 12/31/20, when both the employee paid sick leave and the expanded FMLA are set to expire.
Right after.
They could revert back to not offering FMLA at all as long as they remain an employer without 50 employees under the definitions under the standard FMLA. So there's nothing, they're setting a precedent for granting expanded FMLA, which will expire as of 12/31, and they can revert back to not offering FMLA at all. Again, assuming they're not a covered employer under what we call traditional FMLA.
The final two questions we have is, does the employer have any responsibility to verify the employee's request is true? For example, the employee has no other means of childcare.
Mary Jo or Evan, do you want to take one of you want to take that?
Sure. You don't have an obligation to go out and vet an employee claim, but if you want to take the tax credit, which is obviously an advantage for employers, you can reasonably request documentation to support the employee's eligibility for the leave. And so if, right now, obviously schools are all closed, that seems like a slam dunk, and I'm sure employees are scratching their heads saying, why is my employer asking for documentation that the schools are closed? Of course they can. The reason the employer is asking for that documentation is to support its eligibility for the tax credits. So it is advantageous for employers to try and validate, if you will, eligibility by way of receiving proper documentation to ensure that they're eligible for the tax credits. We've been getting questions about, well, what happens in terms of schools being closed for summer as opposed to schools being closed for coronavirus? And really the threshold is, does the employee have another available child care provider, period? So if schools are closed for summer and normally the kids would go to summer camp, but those are still closed, then it might be reasonable for the employer to say, now that it's summertime, can you, give us additional documentation to prove that you still have a child care gap and therefore you're eligible for this continued leave?
And the last question we received is, has there been any guidance provided on body temperature that would result in sending somebody home?
I believe the CDC has defined like a temperature as anything over 100.4. I'm not sure that employers have to adopt that threshold, but it would make sense for employers to adopt that, recognizing some people run a little high, some people run a little low. Just because you're registering, 99.9 doesn't necessarily mean you have a true fever. So off the top of my mind, that is the number that the CDC is promulgating, but employers, could determine in consultation with their occupational health contacts, what they think is a reasonable threshold.
Excellent. Well, first of all, I want to thank James, Mary Jo, and Evan for participating on this panel discussion. It was very informative, and we ask that if we get any questions, we'll forward them on to you and possibly respond to them.
Thank you.
Check out our website, rockfordil.com, our COVID-19 resources page, and the upcoming webinars and events that I mentioned earlier. With that, I hope everybody has a great afternoon. Thank you.
Thank you, everyone.
Thanks.